Court is now in session.
All right, good morning. We welcome to the West Courtroom panel, which is being reconvened via Zoom. So we're calling our second case for the day, 21-10483, Ralph S. Janvey versus GMAG et al. Mr. Rhodes, I believe you're up first, sir.
Good morning, Your Honors. May it please the Court, Harker Rhodes for the appellants. This appeal is controlled by settled law and by this Court's prior mandate. From the earliest days of our nation, it has been firmly established that a district court on remand cannot award interest that the appellate mandate does not authorize, a principle that the Supreme Court reaffirmed more than 70 years ago in its path-marking decision in Briggs, and that this Court has faithfully followed in countless cases. As this Court put it in Art Midwest, where the appellate mandate, quote, expressly or implicitly directs the entry of a money judgment on remand without mentioning interest, end quote, the district court has no power to add interest that the mandate does not authorize.
But in this case, there was no reference to a monetary judgment at all. There was ruling on that one of many appeals in this case. It was not meant to be the sine qua non of what the monetary relief in the case was it?
Well, respectfully, Your Honor, we certainly agree that the prior mandate doesn't expressly say we direct the entry of a money judgment in X amount for the receiver. But of course, the case law doesn't require that kind of an explicit statement, and this Court specifically said in Art Midwest that the mandate rule applies if the mandate expressly or implicitly directs the entry of a money judgment. And here we think the prior mandate clearly did implicitly direct the entry of a money judgment. And I think that's
not the thing we would have done implicitly. I mean, given the features in this case, up and down, back and forth, etc. I mean, we're all quite aware that words matter, to put it mildly. This is just hardly the routine case. I mean, fought tooth and toenail by excellent counsel. I mean, just back and forth, et cetera, et cetera. I'm not saying other cases don't matter, but this is definitely one. Everything was done pretty intentionally. And, I think you would just have to agree. So we didn't issue a money judgment, just issued the mandate. So, I mean, where's the inference that flows necessarily that you're arguing?
Yes, Your Honor, and I agree that this is not a routine case, but I do think that in light of the mandate in this previous case, the district court really had no other option than to enter a money judgment below. I mean, I think to take the hypothetical, if the district court had looked at this court's mandate and had said, well, I see what the Fifth Circuit did here in its mandate, but I think we really ought to have a new trial on damages here. I mean, I think the receiver would have been the first one in that instance to stand up and say, no, that's clearly not appropriate in light of the Fifth Circuit's decision here. The only course that's available for the district court on remand is to enter a money judgment. So I think this really is a clear case where the mandate implicitly requires entry of a money judgment on remand. I'd point the court to its decisions, for instance, in cases like Martin or Vickers, where there certainly were sort of substantial proceedings to be had in the district court on remand. And nevertheless, this court found that the mandate rule applies because a money judgment was the inevitable consequence of what the mandate required. I think exactly the same thing is true here. So in this
failed technicality, do you believe that the district court would have been entitled to award prejudgment interest had it chosen to do so?
I'm sorry, I missed the beginning of your question, Your Honor.
But for this alleged mandate rule technicality, would the district court have been well within its discretion in awarding the judgment plus interest?
Yes, Your Honor. We don't dispute that if this court had authorized the district court to award prejudgment interest, then for purposes of this appeal, we're not disputing that the district court had the power to do that under Tufta. The only issue that we're raising on this appeal is whether the mandate precluded the district court from making that award of interest and making the award of cost.
What about costs? Why are the costs?
Your Honor, we submit that the mandate rule applies to costs and fees and indeed to everything that the district court does on remand, just as it applies to prejudgment interest. Of course, the mandate rule requires the district court to comply with this court's mandate, and that's true for everything that the district court might be confronted with on remand. It's not narrowly limited to prejudgment interest. But
so it's your position sorry.
No, complete your line. I'm not going to forget.
So it's your position that because we didn't say prejudgment interest plus cost, you don't get either of those.
Yes, Your Honor.
I don't get either of those.
That's correct, Your Honor. Because this court's mandate implicitly directed the entry of a money judgment without making provision for interests or costs or fees, it implicitly precluded the district court from awarding those amounts. And again, we think that's... We
rarely talk about costs in our mandate, but in that way, except cost on appeal, which we have a nice little box to help us in that on our when we send the case to get the judgment entered. We rarely ever would have done that.
Well, that's true, Your Honor, but that's true because the Briggs rule hardly ever applies. Again, the Briggs rule is only applicable in the very narrow set of cases in which this court, by its terms, directs a money judgment, as it did here by reversing and rendering judgment for the receiver. If this court's mandate had instead sort of simply affirmed, or if this hadn't been a case in which a money judgment was involved, then there wouldn't have been any need to give directions with respect interests or costs or fees because the Briggs rule simply wouldn't be applicable by its terms. So again, it's only a very narrow...
Back to your earlier point, though. I mean, back in the early iteration of the case when, the motion was filed to modify the mandate and all of that, I mean, you just alluded to Vickers and some earlier cases, but we looked at Vickers wasn't applicable. That involved a case where the court modified a damages award, and we didn't have that in this instance. I mean, Vickers, there's no ruling about damages, and that's exactly what Vickers had involved in. Some of the other cases, and they're not on par. I understand why you argue, but I mean, they're not on par. Vickers expressly dealt with a situation in which the court modified a damages award, and that was not the case here. It was ordered a rendition of a judgment. You acknowledge that that's what Vickers dealt with?
It's true, Your Honors, that the facts of Vickers are not identical to the facts of this case, and that Vickers did deal with a modification of a judgment rather than a flat reverse and render.
A judgment with a damages award.
That's right, Your Honor. So to be clear, in the Vickers case, the issue of the amount of damages was left open for the district court on remand. So I would say, if anything, this case is a fortiori with respect to Vickers, because in Vickers, it was up to the district court to determine whether to also award an additional amount of damages for mental pain and suffering. Whereas here, Your Honor, there was simply no question that the district court was going to be required on remand by this court's mandate to award damages to the receiver in the amount of the transfers that were at issue. There was never any dispute here as to what the correct amount of damages for the receiver would be. And so, Your Honor, I just don't think there's really any difference between the reverse and remand judgment that this court entered and a reverse and remand judgment if this court had said, we render judgment for the receiver in the undisputed amount of the transfers at issue. That was clearly the import of the prior mandate that this court issued. And Your Honor, I think if there were any question about that, I think that would be made all the more clear by the prior panel's decision not to grant the receiver's motion to recall the mandate and actually authorize the amounts that the receiver requested. So again, the receiver came to the prior panel that issued the mandate in this case and specifically asked that prior panel to authorize an award of interest and costs and fees and to allow the district court to award those amounts. The prior panel specifically refused to grant that relief and to allow the district court to award those amounts. And I think especially in light of that decision, it's really extraordinary for the receiver to claim that the district court still somehow had that authority.
Well, the reality is that, the matter had, as you well know, had been dealt with by the panel. The panel had issued an opinion based on the jury verdict. We, in the midst of, in bank or whatever, we certified a question to the Texas Supreme Court. Texas Supreme Court comes back with an answer, which is sort of contrary to what happened. So King's X, the Texas Supreme Court rules on the issue. So what the panel did is, in effect, give apply what the Texas Supreme Court says the law is in terms of the defense. So it just puts in play what the highest court of Texas says is the law in the case. Nothing more, nothing less, because that's dramatically different than what had come out, on the basis of the jury trial. So the panel gets it and says, okay, now everybody knows what the law is, and so here's judgment that's consistent with that. Nothing more, nothing less. You get a motion to modify the mandate, to quote, clarify, I think is what the motion was, blah, blah, blah. The panel left in place sort of status quo based on the Texas judgment. So that's in reality what happened.
But Your Honor, I don't disagree with any of that. And I think Your Honor makes a good point that the receiver got sort of exactly what he wanted from the judgment in the prior appeal. He got the reverse and render judgment that he asked for in his papers. But I think to a certain extent, the receiver is something of the dog that caught the car here, and that he got exactly the sort of decretal language that he was looking for, but that decretal language didn't actually authorize the award of prejudgment interest and fees that the receiver later sought from the district court.
But having pushed the case back down to the district court in a posture it wasn't before, I hear you in terms of the mandate and what you're arguing, but best, the district court gets the case with a free rein, so to speak, to do or not do whatever it then chose appropriate, given all that, all the dust that's been kicked up itself for either party to convince it up, down, sideways, or what. How does it, I know it's a lot of money, now don't get me wrong, but how does that tilt the system in terms of the judge back down with everything, entering whatever he or she, in this case, he thought appropriate, because the Court of Appeal hasn't tied its hands one way or another.
So, Your Honor, the Court of Appeals certainly could have issued a mandate that wouldn't have tied the district court's hands. The Court of Appeals in the prior appeal, the panel could have issued a mandate that said, we reverse and remand for further proceedings consistent with this opinion. And in that situation, we grant that the district court would have had the authority to award additional amounts. But that's simply not what the prior panel said in its mandate. And what the prior panel said instead was, we reverse and render judgment for the receiver. If you compare that, the language in the Briggs case itself, the Second Circuit in the Briggs case itself, in its initial opinion, said judgment reversed, judgment to enter for the plaintiff on the verdict. And similarly, we think that language likewise, it doesn't say anything about interest. And most importantly, it doesn't authorize the district court to, engage in further proceedings on remand to add additional amounts beyond what the mandate itself authorizes. So I do think
could we talk about the Briggs rule, please? Is it your position that the Briggs rule is both broader than and wholly inclusive of Rule 37B? And if so, what is the point of Rule 37B? And second, can you cite any case that has specifically applied either Briggs or Rule 37 to attorneys' fees and costs? Those are two separate questions. Thank you.
Yes, Your Honor. So with respect to the first question, yes, we do think that the mandate rule is broader than Rule 37B and inclusive of Rule 37B. And the purpose
of the Briggs rule. The Briggs rule.
The Briggs rule. Yes. So the Briggs application of the mandate rule.
So it's wholly inclusive and broader.
That's right, Your Honor. And
so what's the purpose of the rule then?
We think it's exactly what the drafters noted in the advisory committee notes. Namely, it serves as a reminder to the court and counsel of the Briggs rule. It's simply a helpful guidance that litigants can point to and that the courts can look at to remember that the Briggs rule does in fact require this result. As with respect to your second question, as to cases regarding attorneys' fees, we would point the court in particular to the Kansas City Southern Railway case. I think that's our best case for the proposition that the mandate rule does in fact preclude or can in fact preclude an award of attorney's fees in a case where the mandate doesn't specifically address attorney's fees. So that is a case in which the Supreme Court specifically held that a mandate that was silent on its face as to attorney's fees did preclude the district court from awarding those fees on remand. Now, I grant you that the procedural posture in that case was a difficult one, fairly complex and somewhat different from the posture here, but we think that does firmly stand for the rule that the mandate rule can preclude a district court from awarding fees on remand where the mandate is silent.
Do you also concede that the attorney's fees would be within the discretion of the district court? I asked you about the prejudgment interest. Do you concede that that's otherwise proper, but for this technical argument that you're making today?
Yes, Your Honor. The argument that we're making today with respect to fees just goes to the scope of the district court's power under the mandate rule. We're not challenging in this appeal the district court's exercise of its discretion, except for its absence of authority to award those fees. If there are no further questions at this point, Your Honors, we'd ask that the district court's decision be reversed and reserve the rest of our time for rebuttal.
All right, thank you, Mr. Rhodes. All right, we'll hear from you, Mr. Sadler.
Good morning to the panel. There are 3 points that I think are relevant here for the panel to consider. And Judge Stewart, you've hit on one. Judge Elrod, you've hit on another. But let's start with the first one. Consider the impact of the argument that is being made to you. That the receiver, though he was vindicated at every level after 5 years of up and down appeals, that the receiver, and by extension the Ponzi scheme victims, are to be stripped of 40% of their recovery to which they're absolutely entitled under state law. As Judge Elrod, you just pointed out, attorney's fees, prejudgment interest, absolutely entitled under state law. Stripped of that by total silence. Not a word in the opinion, no briefing, no argument, no litigation, nothing about remedies, but the receiver and the Ponzi scheme victims are to be stripped of 40% of their recovery. No case has been brought to you that supports such an awful result. Second point, the mandate rule. It's not complicated. The mandate here is not complicated. The mandate says judgment for the receiver, period, full stop. What does that mean? Receiver wins. Why did we have a mandate that was so succinct? And I know I'm talking to one member of the panel and I'm not trying to be a mind reader here, but why was there such a succinct mandate? Because it was a 1-issue trial and a 1-issue appeal. The only issue litigated, briefed, both district court, jury, and the appellate court was, did Mr. Magnus have a valid affirmative defense? After 5 years, the answer to that question, the only question that was presented, was no. He does not have a valid affirmative defense. What happens when his affirmative defense falls away? Receiver wins. That's the end of the case. What happens then? How does the district court carry out a mandate that says receiver wins? Well, it goes back to the district court to consider all of the remedies available to the receiver now that he has been declared the winner. And I know there's been this focus on the so-called undisputed money judgment, which, as you know from our 28J filing, is anything but undisputed. There's already another appeal docketed at the Fifth Circuit over this so-called undisputed money judgment. But 24008, the statute, Tufta, provides a range of remedies, separate and apart from attorney's fees and prejudgment interest, that the receiver would be entitled to ask the district court for once he's declared the winner. So the idea that somehow there's this implicit or inevitable consequence that the only thing that Judge Godbey was to do when he got the remand was simply write some number on a piece of paper and hand it to the receiver, there's just no support for that. There is no support for that. So I want it to be very clear. Not only did Judge Godbey not violate the mandate rule by doing exactly what he did, the only way he could have complied with the panel's mandate is to do exactly what he did, which is consider the issue of remedies, which had never been before briefed, litigated, argued, let alone decided by the appellate panel. Let's move to Rule 37B, because this is how we got there. And I'll just remind the court, when the panel decision was fully, and finally final, that is, we had made our trip up to the U.S. Supreme Court, Mr. Magnus' petition for cert has been denied, we finally come back to the district court, and it's time for the receiver to get his judgment and his remedies. That's when this 37B argument is first raised by Magnus. Oh, no, you can't award attorney's fees. You can't award prejudgment interest because of 37B. We looked at 37B, and just as it has been pointed out here, it doesn't apply. And the cases they brought to you, Art Midwest, the Nisho Iowa case, Those don't say that 37B applies in this kind of circumstance. Quite the opposite. 37B doesn't apply. We raised the issue in our motion, and I'll just be very blunt, because we didn't want to be here today. And we knew that this was going to result in yet another appeal. But here we are. But there is no case that's been brought to you that says 37B applies in this kind of circumstance, cuts off our substantive state law rights to attorney's fees and prejudgment interest. There just is no such case, because it wouldn't be the law. You know, it's astonishing to think about. You know, this committee that puts together these rules goes to the trouble to write a commentary, and apparently a lot of people don't read it. Because if you read the commentary to Rule 37, you would come away with the clear understanding it has no application to this case, and it doesn't. So those are the 3 points. There is no case that's been brought to you that says the receiver's 40% of his recovery, to which he's absolutely entitled, is stripped away because the mandate did not contain the words "and further proceedings consistent with this opinion." There is no such case that says that. There is no violation of Briggs here. This is not like Briggs. We don't have a jury verdict that says $42,500 and not a penny more. We had a trial over an affirmative defense. That's the only thing that was at issue at trial, the only thing at issue in your appeal, the only thing at issue at the Texas Supreme Court. So the idea that Judge Godbee, his hands were tied by a mandate that simply says receiver wins, there's no case that says that. And none of the cases they brought you say that. Everything the district court did was absolutely proper and the only way he could comply with the mandate. And it is our position that the receiver should receive the attorney's fees awarded. There's no argument the number was wrong. The prejudgment interest, the reason it's a big number, as you point out, Judge Stewart, is because Mr. Magnus had $80 million in fraudulent transfers that he could use for 12 years. That's why the prejudgment interest number is so big. But we're absolutely entitled to it under state law. I would be happy to answer any questions the panel has. I would be happy to surrender the balance of my time as well. The judgment, the decisions of the district court should be affirmed.
Other questions from the panel? Okay. All right.
Thank you, Your Honor.
Back to you, Mr. Rhodes, for any rebuttal if you would like.
Thank you, Your Honor. Just very briefly. First, Your Honor, the receiver suggests that simply because these issues weren't litigated in the first appeal, that somehow the mandate can't be binding as to those issues. But that argument is squarely foreclosed by Briggs, in which, of course, the issue of interest was not litigated in the first appeal to the Second Circuit, and the Supreme Court nevertheless found that the Second Circuit's mandate was binding on that issue. The second, the receiver suggests that, because this judgment was simple and straightforward, it left room open to the district court to take whatever proceedings the district court deemed necessary on remand. But, Your Honors, again, I simply just point to the Briggs case, in which the decretal language from the Second Circuit said simply judgment to be entered for the plaintiff on the verdict. That language was controlling, and because it did not mention interest, the district court had no power to award it. Again, if the district court here had looked at this court's simple and straightforward mandate and said, well, the mandate doesn't expressly preclude a new trial on damages, or doesn't expressly preclude me from considering some other defense to liability, I think the receiver would have been the first one to say that it was not open to the district court to do anything other than entering a money judgment for the receiver on remand.
In light of what happened, why is that a realistic example? You don't dispute the history here. The trial was over the affirmative defense under Tufta. That's what the question that was certified, that went up straight back. It's just like when it came back to us, there was nothing for us to discuss. Texas Supreme Court says this is the answer. That's it. So there wasn't anything for the Fifth Circuit to jack around. Well, we still want to make an eerie guess about this. Once it was certified and they answered the question, that was it. Straightforward. So the panel takes what the court says is the law, implements it, issues the mandate on the judgment straight up, goes back down to the district court. How could they have been asking for a new trial and all of that kind of stuff when the issue that went up was on the affirmative defense? I hear you, but that just seems a little bit unusual that they would have even been able to make that, or anybody would have been able to, retry the whole case.
Well, Your Honor, and we agree with that. I think the point is just that in the same way that the district court would not have had authority to entertain that kind of a motion, it likewise has no authority to increase the amount of the judgment by adding prejudgment interest that the mandate doesn't award either. So we're not trying to avoid the history of this case in any way. We affirmatively embrace the history of the case, and we think it shows that there was really nothing for the district court to do on remand other than simply enter judgment for the receiver in the amount of the transfers at issue. The third point that I'd like to make very briefly, Your Honors, is just to note that we do think that the receiver is really missing the point with his focus on Rule 37B. As I suggested in my answer to Judge Elrod's question, the fundamental problem with the district court's decision below is that it violates the mandate rule, not that it violates the strictures of Rule 37B itself. Because, of course, Rule 37B itself, it provides guidance to the court in entering the mandate, the appellate court, not to the district court. So the district court's error here was a violation of the mandate rule. Rule 37B simply confirms that the district court erred. If there are no further questions, Your Honor, we ask that the district court's decision be reversed.
All right. All right. Thank you, counsel. To both sides. I mean, this is just one of those cases that, it's kind of been here a while. But anyway, we take what we get. We appreciate the excellent lawyering on the case. And, guess we have lifetime tenure, so we'll deal with this case for the lifetime about tenure. I probably shouldn't have said that, but in any event, I'm not making light of it. But, it's a lot of money involved here, but I don't want you to think in any way that we don't take the seriousness of it. There's nothing you've argued frivolous at all. So please don't take anything away from the questions of not giving due diligence and digging down deeply. It's very important. Lots of money, lots of interest. So I don't want you to take any away from anything I said or giving you a backhand of, why we're here. I mean, this is what we do, complex litigation. So we appreciate the briefing and argument. The case will be submitted, and we'll do our best to get it out of here, and stay tuned for whatever else, may be. So hopefully on the COVID side, all is going well, on your end, Mr. Rhodes.
Thank you, Your Honor. Yes, we feel a lot better than we did last week, and we appreciate the court's accommodation in having this argument be remote. Well, this is a tool we would have never known about but for the pandemic, but, we pull it out of the toolbox when we have to. So this is definitely better than postponing a case. I guarantee you that. So we all agree with that. So at any event, I won't prolong it, but thanks to everybody. This will conclude the docket for our panel this week. The case will be submitted along with all the other cases for this week, and we stand adjourned. Thank you.
Thank you.
Thank you, Your Honor.